Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about flooding. Cases that should have gone to the Supreme Court of Canada, but didn't. In 2013, the City of Toronto experienced an insane amount of rain. This led to widespread flooding all over the area, which affected one banquet hall in particular. There was about $500,000 worth of damage to the banquet hall. The banquet hall had an insurance policy in place that covered it in the case of flooding. The insurance company took the view that the flooding was not flooding, but was in fact surface water, because the flooding didn't occur inside the banquet hall, but instead had occurred in the streets, and the surface water on the streets had leaked into the banquet hall. The Supreme Court of Canada was asked to determine whether or not flooding constituted flooding just within the confines of the building, or the ingress of surface water from other areas into the building, thereby flooding the building. The Superior Court in Ontario actually agreed with the insurance company and found that the insurance policy didn't apply, but the Court of Appeal overturned the judgment, determining that this would essentially nullify the insurance coverage in all circumstances where rain leads to flooding and the flooding impacts buildings and businesses and vehicles and anything else that can be subject to flood damage. This case raises an important issue about the certainty of terms in coverage in insurance policies. As somebody who lives in Vancouver, where there's a lot of rain, the idea of flooding from rainwater coming from the street and into your building is not outside the realm of normalcy. And our office itself has dealt with the question of whether or not there's been a flood or damage in the interpretation of terms of an insurance policy. This was an opportunity for the Supreme Court of Canada to decide one of the rare insurance cases that comes before it, and to decide it in a way that interprets a policy in a way that makes sense to most people. As the Court of Appeal found in this decision, most people would understand flooding coverage to cover what had happened in this case. And the Supreme Court of Canada could have talked about the way that insurance contracts should be interpreted so that the meaning of the terms to the insurer versus the meaning of the terms to the ordinary person purchasing the insurance contract, and the tension between those that often occurs, can be resolved between the parties. This was an important opportunity to allow certainty of terms in contracts to be considered by the Supreme Court of Canada in a way that's going to affect Canadians who are making insurance claims across the country every single day. This was an important case, and the Supreme Court of Canada, I think, missed the opportunity to see how this case had so much importance to the Canadian legal landscape as a whole. Hopefully there'll be another case, hopefully with not too much damage, and the Supreme Court of Canada will have the opportunity to interpret these insurance contracts in a way that's fair to everybody involved. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.